Well, today we have the great pleasure of welcoming Professor Lucas Grosman from the University of San Andres in Argentina, here this week to teach in our global law project. On a personal note, it's quite nice to see Professor Grosman again. We actually met 10 years ago, a little over 10 years ago in Yale when he was a GSE student and I was a JD student, so it's great to be reunited in this particular context. So welcome, Professor Grosman.
Thank you very much, Jed. It's a pleasure for me to be here.
And so I thought, like many of the people who come through our program, you're an internationally esteemed legal scholar beyond your duties of being a dean at San Andres. So I thought many people would be interested in how your particular career and the various sort of international stops along the way that led you to become dean today.
Okay. I studied law at the University of Buenos Aires in Argentina. I graduated as a JD. The degree in Argentina is called just lawyer. And after, I think, more or less 3-4 years, I went to Yale for my LLM. That was from 98 to 99. Then I came back to Argentina and I worked at the antitrust agency and later became an antitrust commissioner. I served in that position for 2 years and then went back to Yale to pursue my JSD. When I finished that, I went back to Argentina, and from that moment on, I've been teaching at Universidad de San Andres. And a couple of years after my arrival, I became the dean of the law school, and I'm still in that position.
So how would you compare your career, right, leading up to this moment, to that of like the typical Argentinian law professor? Is it unusual, this combination of public service and academic study? I mean, how does this sort of play out in the Argentinian context?
Well, I would say that the typical law professor in Argentina is still a part-time professor. So he or she practices law, probably serves at a court of justice, and teaches law sometime during the day in his or her free time. So the model of full-time professors is still pretty rare, pretty exceptional in Argentina. I think it's the same here in Brazil. In that sense, my career was definitely different.
And so one of the things of why we're lucky to have you here is we try to expose our students to these types of international and comparative perspectives by having scholars such as yourself come and teach courses. So I thought you could talk a little bit about the course that you're teaching and why you thought this would be a course that would appeal to Brazilian students or the ones specifically here at FGV.
Of course. Well, the topic of my class is social rights and scarcity. In other words, how social rights, the enforcement of social rights is affected by the fact that usually we deal with scarce resources, and therefore courts are in a position that is particularly challenging to them because it's not the usual situation they face. Adjudication involves other aspects. It involves trade-offs, in that sense, they certainly differ from traditional cases. So why could it be relevant for students at FGV? Well, in a sense, Argentina, Brazil, Colombia, India, many countries around the world are facing similar challenges regarding social rights. Especially in the mid-90s, courts started to enforce such rights. Before that, the traditional doctrine was that these were merely programmatic rights, which meant that they were not enforceable before the courts. As they say, they were not justiciable. They were something like policy goals, but the courts were not supposed to make them enforceable. This started to change to a large extent due to the influence of scholars and advocates in the social rights field. And that change, I would say, that started to happen in very different places at more or less the same time. Go ahead.
So, yeah, so one of the things that naturally strikes me is that these are, again, are very similar to current debates about the role of the judiciary when it comes to social rights in Brazil. In particular, the legitimacy of the STF, the highest court in Brazil, in enacting these types of policies has been quite, controversial, and the relative popularity of the judiciary has shifted in recent years. And so, what has been the reaction in Argentina politically to courts taking on this sort of larger role in implementing social rights?
I'm not sure about the political reaction because, to be honest, the approach by Argentine courts has not been at a large scale. Mainly what they have done is enforce the right to health. Occasionally housing, but mainly the right to health. And I understand that in other countries, and certainly in Brazil, the trend has been similar. Courts have been much more active in enforcing the right to health than, say, education, housing, minimum wage. So it's an interesting question. Why? That's true. What is it about health that, for some reason, courts find it easier or more plausible to intervene in more active ways? I would say that in Argentina, at least, this active role by the courts regarding the right to health has been politically welcome. Rarely has it implied an intrusion in the areas typical of policy making, which policymakers particularly resent. We haven't experienced such a reaction. But to be honest, I'm pretty critical or skeptical regarding the approach that courts in Argentina, and I would also say, as much as I know, in Brazil, have adopted regarding social rights. I think basically they have tried to disregard completely the issue of scarcity. And the truth is that when you do that, trade-offs happen anyway. It's not that you can just ignore them, but the implication is that the way they happen usually is unnoticeable. It involves long-term policies or less visible aspects of policy making, for instance, in the area of healthcare. So my own approach is that problems of scarcity should be faced in a more direct way, that courts should acknowledge that such problems exist, and they should look for a theoretically sound way of approaching scarcity. So far, I would say that reactions to scarcity are erratic. Usually, the scarcity defense is completely disregarded or ignored in the case of healthcare, while it is treated in a much more differential way when we are speaking of housing or education, as I said. So in that sense, I mean that the reaction has been erratic. It's not theoretically sustainable.
So is that one of your, in teaching the course here this week, is that one of your primary goals, is to sensitize students to that particular type of trade-off?
Absolutely. I don't want them to come out of the course with easy answers. I think that there's no such a thing for this problem, but I want them to realize actually that there is a problem and that we are in a transition situation in a sense. The recognition of social rights as enforceable rights is relatively new, and I don't think that we, lawyers, practitioners, certainly courts, have the conceptual tools, the conceptual framework to address issues of scarcity in a comprehensive, sound way. I think that there's some intuitions, there are some attempts, but there's still a lot of theorizing demanded in order to achieve, I would say, that the next level in the enforcement of social rights.
Well, that should be great for, I mean, we were actually just discussing a very similar issue on the limits of rights in my course earlier today. So I think especially as FGV looks especially at this interface between law and policy, this is something that our students have a great advantage or opportunity to take advantage of. So the other thing in sort of your life as dean is thinking about legal legal education and innovation in the South or Latin American context. So, one of the things that is part of the dialogue here at FGV is the relationship to our school as a set of internationally active scholars. We have tried to include international perspectives in our debates about Brazil, but there's often this tension, right, between the role of the law professor as, again, an internationally active scholar, but someone who's also facing Brazil at the same time. Are these similar types of dynamics that you find, facing San Andres as it attempts to do similar types of innovation in Argentina?
I think they are, absolutely. I think that we face similar challenges, and in a sense, the difficulty is that our legal culture is not used to this, as you said, more international approaches, more related to policy making, to an interdisciplinary approach, and therefore the reaction of the mainstream profession is not always what you would expect. So you have to move with caution, because you don't want to alienate the profession. You don't want the lawyers, practitioners to think that what happens here, that what happens at the FGV classrooms is completely relevant to what happens out there. If that's the general reaction, then we have a problem. And I think that's the kind of challenge we face at San Andres as well. So we want to maintain strong ties to the profession. We have professional, practicing lawyers teaching as well, along with full-time professors, so that the students feel that they get a combination, what I like to say, the best of both worlds. People who are thinking about the law, who are critical and have more time to be analytical about it, and people who know it in practice. I think that in that sense, I think we should aim at a model that to some extent differs from the Anglo-American one, where full-time professors are the rule. I think that for countries such as Brazil and Argentina, certainly at this stage of development of legal education, we need some sort of mix, a combination of full-time professors, but also practicing lawyers, judges, people who are in the day-to-day practice of law. Is it a challenge? Of course, but I think that the answer to that challenge is to move gradually, to gain prestige, and to make sure that the profession understands that what we do here is not only relevant, but it's also the best way of understanding the law.
So how has the sort of reaction of the larger Argentinian legal profession been to some of the changes that you made, and sort of the response to your students? How have they, on the sort of demand side, how have they sort of responded to the types of innovations that you've unfolded?
Well, the market, so to call it, has reacted very well. I think that our graduates are highly appreciated by the market, of course. I think that that's true also about FGV, for what I understand, and that must mean something. I think that the more meritocratic legal environments tend to react very well, because they realize that our students have very sharp analytical skills. It's not only that they know the law, but they know how to analyze the law, how to be critical about it, and that gives them a depth that the traditional law student will not easily achieve. So in that sense, I think that we definitely, by we, I mean law schools like the one at San Andres and at FGV, we definitely have an edge. And I think that the market perceives that. Of course, we are relatively small, and therefore that change is going to be gradual, maybe not as fast as we would like, but I think that there's reason to be optimistic.
And so as far as like your professors, when it comes to their academic production, right, and wanting this way of both, facing the international audience, but speaking to Argentinian problems, how does that affect just what they produce on an academic level?
I think that you're pointing at a huge challenge, because countries like Argentina and Brazil don't necessarily have the channels for theoretically profound scholarship to be published. And therefore, our professors may tend to look abroad to find those channels. But that comes at a price, and the price is local relevance. You know, if you want to publish in an international American journal, maybe you will have to write about things that are not the most relevant locally. And I think we should resist that temptation. I think that we should try to create incentives for our professors to produce things that are locally relevant, that attempt at the improvement of our local institutions, even if that means publishing at places whose standards are not as high as certain international journals. I think that still we should try to keep an agenda, at least in certain areas of law, which is sensitive to local problems.
So in this vein, often people talk about like North-South relationships between law schools, changing these particular dynamics, but what type of possibilities do you imagine for regional collaborations between schools like FGV and San Andres as Latin American, South American institutions to help facilitate these types of changes that they're talking about? Is there potential there for dialogue and interaction?
A lot. I think that we should definitely explore that more deeply, because maybe that's where the key lies, in finding arrangements of collaboration that make it possible for us to find that scale that sometimes is not present locally, but may be present regionally. And by seeking institutions which in many respects look alike, I think that we might find the way to develop in an autonomous way, and without having to, as I said, sacrifice local relevance, which is so important for us.
No, I think that's definitely something, sort of a sentiment that we share here as well. So I want to take the opportunity again to thank Professor Grosman for coming here and sharing his experiences and his perspectives with our students. This is exactly the type of experience that the Global Law Program was created to give both us as scholars, personally getting to see fellow compatriots in this way, but also giving our students the ability to see these wide range of possibilities that exist internationally, both for collaboration and for their own sort of career advancement.
Well, thank you very much. It's great to be here, and this program is definitely the sort of thing that we would like to imitate.
Great.